and thank you all for appearing. We will now move to the matter of Clement Xavier versus GRAPETREE Shores, Inc., number 14 of 2020.
Good morning. Good morning, Chief Justice Hodge, Justices Cabret and Swan. My name is Tom Alcon, and I represent the appellant plaintiff Clement Xavier, who has appealed a final decision of the Superior Court denying his request to vacate a judge magistrate's order compelling arbitration, removing Xavier's case from the jury division of the Superior Court.
Okay. Would you like to reserve any time for rebuttal, Attorney Alcon?
Yes, I would reserve 3 minutes.
Very well.
Pardon me, Chief.
Yeah.
Can I have just 5 minutes?
Okay, you need a break for 5 minutes?
Yeah, I just.
Okay. We'll stand in recess for 5 minutes. Attorney Alcon, we'll start the time back when we come back.
All right. Okay.
I missed that. Well, I'm sorry. Yeah. And the important thing,
All right, Chief, I'm back.
So we can get started. We will
Yes.
start over.
Yes.
Attorney Alcon, you may proceed. You reserve 3 minutes, so you can start.
Thank you, sir. Okay. Excuse me. The basis for my client's request to vacate the judge magistrate's order is grounded in the recognition that the preclusive effect of such a ruling determines that the Superior Court will be unavailable to entertain the dispute. I would say, in other words, the motion is functionally equivalent to at least 2 of the 8 motions found in the Magistrates Act that bars judge magistrates from hearing them, and that is failure to 12b6 and 56, summary judgment and failure to state a cause of action. Our case relies heavily on this court's analysis in Martinez versus Columbia Emeralds, cited in the brief, 51 VI 174. In Martinez, this court pointed out, when presented with a motion to compel arbitration, a Superior Court judge would first determine whether it was filed as a pre-answer motion. If so, he would treat the motion as a 12b6 motion, and the court then, in determining the merits of the motion, would afford the plaintiff the safeguard of having all its allegations taken as true and all inferences favorable to the plaintiff would be drawn. However, if the motion is filed after an answer is filed and matters outside the pleadings are presented and accepted by the court, the motion is treated as one for summary judgment. The Superior Court, in Martinez versus the Superior Court, Your Honor, following the teaching of this court in Martinez, Superior Court judge in Burke versus Treasure Bay treated a motion to dismiss the complaint and order arbitration as a motion as one for summary judgment, since outside matters were filed and accepted by the judge. Now, once there was the enactment of the Magistrates Division, Superior Court judges were granted an additional option, in addition to what I've just stated. Pursuant to Section 123b2, the Superior Court judge could request a magistrate judge to conduct hearings and submit findings of fact and recommendations to the court on any motion accepted from their authority in Section 123b1. But the magistrate judge could not hear and determine such motions. Now, in the case below, defendant filed a post-answer motion to dismiss and compel arbitration, but had, prior to filing such motion, filed additional matters in court, the arbitration documents, and accordingly, the court could have treated the motion as one for summary judgment and afforded the plaintiff the protections under such a motion. However, he did not. He forwarded the matter to the magistrate judge to hear and determine. And alas, this appeal was forthcoming, and we now are before this court.
Okay, Attorney Alcan.
Yes, sir.
Now, you agree that this had been a referral from the Superior Court judge to the magistrate judge, and the magistrate judge made a decision, correct?
Yes, sir.
And as allowed by the rules, you sought reconsideration so that it would go back to the judge to decide whether or not the magistrate judge made the correct decision. Is that right?
Not necessarily, Your Honor.
Well, the magistrate judge ordered arbitration.
Yes, sir.
You argued that it was too costly, so you sought reconsideration. you all agreed on the cost and you withdrew the motion for reconsideration. So when you withdrew that, then you basically agreed with the magistrate's ruling?
No, sir. No, sir. What we did, once the magistrate issued his order, okay, we understood we had to go to arbitration. We filed a motion to the Superior Court judge for reconsideration based upon the cost. But we had previously filed our motion in opposition to the granting of going to arbitration. We argued that they had waived it. That issue we never withdrew. In other words,
Attorney, somewhere along the way, my understanding of this case seems to be quite different from yours. Number one, without getting into the facts as to where he fell down in the DVDV or otherwise, but am I correct? There's a membership agreement between your client and DVDV. Am I correct?
yes, sir.
All right, and that agreement explicitly, expressly, and implicitly says that there's an agreement to arbitrate. Am I correct?
Yes, sir.
Okay, all right. Now, would you not agree that under Title 4, Section 123, that allows a Superior Court judge to remand certain pre-trial motion, non-disposable motion to a magistrate for determination? And in this case, it was a motion, as I understand, to arbitrate. Nothing about resolving any of the merits of the case, just so whether or not that they should go to arbitration. My understanding also that subsequent to that, you might have filed an opposition to go to arbitration, but subsequently, because the DVDV's people decided that they would pay for the arbitration, your client said, all right, I go to arbitration. And he showed up at arbitration. I understand that this arbitration took about 3 days, in which your client and everybody was allowed to hire from both professional expert witnesses and fact witnesses as to what transpired that gave him that injury while he was at the casino at the gambling table. But the fact is that when you look at Title 4, Section 123, is there anything in there, what language in there that would have prohibited a judge for the Superior Court for transferring to the magistrate a motion to go to arbitration, or particularly when you had an agreement? But am I correct that 123, Section 123 is the vehicle that drove, is the engine that drove this vehicle to arbitration, along with your client agreeing to go to arbitration? And if you agreed to go to arbitration, did you not waive that issue of arbitration? And when you participate fully and extensively in the arbitration process?
The answer to that, sir, is my client, on the time before it went to a magistrate, when the other side filed the motion to compel arbitration, we opposed it. We never withdrew that opposition. What we did do, after we lost the arbitration, we asked the court to reconsider it because the expenses were too high. We didn't withdraw our opposition to the
All right, but what was the basis for the motion for reconsideration? The monies, right, to finance the arbitrary process?
Yes.
Which DVDV said, we will pay up. We will pay for everything. And apparently, your client, or in the record, according to the record that I read, said, all right, if you're going to pay for it, then we off and run into arbitration.
We will go to the arbitration because of the compulsion of the magistrate's order. Your Honor.
To go to arbitration?
I mean, we went to arbitration. We withdrew not our argument that it had been waived by the behavior of the casino. We made a separate motion for reconsideration because the costs were too high.
Attorney, what difference does it make, particularly, you see, we have to be very careful. We can't play loose and fast with the law. If, in fact, that you have an agreement for membership at DVDP, that agreement have a time for arbitration, the Superior Court says, let me send this on to the magistrate because it's a non-disposable motion. It don't resolve anything. And under 123, the jurisdiction and power of the magistrate division, a magistrate can make a determination as to whether it should go to arbitration. And there's opposition to that by you, your client, and because of the money and the cost. And DVDP say, don't worry, we will pay the attack cost. And the parties are off and running at 3 days of arbitration. Expert witnesses are coming and talk about the bench, about the stool, his injury, fact witnesses, and all like that. And then when he get an adverse judgment now, he's saying that, well, you know, maybe the magistrate might have exceeded his or her authority. I have a problem with that because I don't see where any place in the law, and I hope that you can direct my attention to it, where we can look and say that the magistrate exceeded his authority by ordering this to arbitration. When the parties agree, even if the magistrate didn't order it to arbitration, the parties agree and you have the agreement to go to arbitration?
I'll be pleased to answer that, Your Honor.
Yeah, go right ahead.
We signed an arbitration agreement. Then, when the casino moved for arbitration, we filed a motion saying that it was invalid because of their behavior. They waived the right to arbitration. The Superior Court judge, instead of ruling on that dispute, sent it to the magistrate judge.
Where is the waiver?
What?
Where is the waiver? Because this is my understanding. My understanding is you said that there's a waiver because of a protracted period that it took for the parties to get a response from the magistrate, which was 2 years and 2 months. Well, that can be on DVDP. And then you raise the issue of maybe we had some extensive discovery before the arbitration was ordered, and therefore there was a waiver. But when I look at all of the discovery that was prior to the order, I don't the filing of the motion, because I deemed it the filing of the motion was when it is. But to say that if a magistrate is going to take 2 years and 2 months, that's not on DVDP. So DVDP continued, I guess, the process of discovery because we don't know how the magistrate is going to rule. But at the time that they filed their motion to compel arbitration under the agreement that the party subsequently agreed to, there was nominal or limited discovery that was conducted. I don't believe that any deposition was even done before the motion was filed. So I think that a cutoff point would be when the DVDP filed the motion to go to arbitration. The fact that a magistrate might take 2 years and 2 months or 10 years to rule on it, that shouldn't be a waiver to DVDP.
Okay.
It's not.
All right. Okay. Attorney Alcon, I was gonna ask you to think of one thing while we go to your opposing counsel. If you objected to arbitration, claiming that it was waived because of the discovery that was conducted and the time had passed, when you then agreed to go to arbitration, you withdraw your motion once the cost was resolved. Didn't you waiver by actually participating in the arbitration?
I can give you
So
a
think about that, and we'll come back to you. We'll now go to Attorney Kaczynski. You got your 15 minutes.
Thank you. Good afternoon, Your Honors, and may it please the courts. This case can be decided upon the actions of the plaintiff when he willingly participated in the arbitration after he withdrew his motion to reconsider the order compelling arbitration. And because of the plaintiff's actions, this court should affirm the ruling and judgment of the Superior Court closing this matter. To the extent that the court chooses to address the issues raised by the appellant, the court should follow the Third Circuit and find that a motion to compel arbitration is a non-dispositive motion and within the authority of the magistrate. And also the court, in line with its holding in White versus Bacano, should find that Treasure Bay did not waive its initial right to compel arbitration. But in this instance, it's important to understand and keep in mind that the plaintiff, essentially withdrew his challenge of the arbitration agreement. In this instance, after the judge ordered and compelled the arbitration, the plaintiff filed a motion for reconsideration. And the plaintiff, in his opening, in his opposition, the issue of waiver. But when he filed his motion to reconsider, that was not an issue that he ever addressed with the court. The only issue he put before the court in his motion for reconsideration was the costs and fees associated with that. And then he reached an agreement with Treasure Bay and withdrew that motion and then freely and willingly participated in that arbitration. And this court in Bashidi versus Choo-Choo Park Limited held that if a party participates in arbitration proceedings without making a timely objection to the submission of the dispute to arbitration, that party may be found to have waived its right to object to arbitration. And based on that case and the facts here, it is clear that the plaintiff made an untimely objection. First, this issue about the magistrate's authority wasn't even raised until after the arbitration occurred. And then with respect to the waiver, the plaintiff, the court doesn't even need to find an inference of waiver. There's an express, essentially, agreement to arbitrate by when he withdrew his motion to reconsider and agreed to the costs and fees and then participated freely in the arbitration. And based on that case and the facts here, the court should affirm the ruling of the Superior Court and close this matter. With respect, though, to the issues, raised in the appeal, if the court chooses to address those, the court should first follow the Third Circuit's approach in WAPA versus General Electric and find that a motion to compel arbitration is non-dispositive. As this court pointed out initially with the appellants, it's not listed anywhere in a statute, and it's not a equivalent of any dispositive motion. The First Circuit noted, and the Third Circuit adopted this approach, that a motion to compel arbitration doesn't address the merits of the claim, it doesn't dismiss any of the parties, and it doesn't dismiss any of the claims. The best approach and the most consistent approach would be to stay a matter, compel arbitration and stay, and then afterwards retain the jurisdiction to address any issues that are being addressed. And in the plaintiff's
that's the kind of best practice, though. When you actually file a motion to compel arbitration, are you saying to the court, this matter does not belong in court, it belongs in arbitration, and this court should refer it to arbitration and dismiss the case? While the court may have the option of staying rather than dismissing, isn't it really a motion to have the court relinquish jurisdiction and refer it to the arbitration that the parties agreed to? And doesn't it can't amount to basically a dispositive motion to dismiss when you actually file arbitration? Because you're saying the court doesn't have any jurisdiction over it. And I know that it's been developed to be the best practice to probably stay it rather than dismiss it. But that's an option that the court has, right?
Your Honor, the court does have that option. But first, I would, a motion to compel arbitration is not necessarily saying that the court doesn't have jurisdiction. It's requesting the court to honor an arbitration agreement. But with respect to the dismissal, that approach is not really applicable in many cases. And this was noted in a footnote in the Prentice case where, you know, certainly not all claims are going to be subject to arbitration and not all parties are going to be subject to arbitration. So having a ruling where a situation to allow a court to dismiss a case once a motion is filed and granted, you know, is not going to necessarily be the rule that's going to be able to be applied consistently for all cases, because, you know, we would want a consistent ruling and a consistent rule where a party moves for compel arbitration, that should be stayed, and then the remainder case, if necessary, can move forward, and the court can also, you know, retain jurisdiction, because afterwards the court needs to be able to either enforce the arbitration agreement, revoke it, modify it, confirm it, or address any other issues. And if the court dismisses it as soon as it compels arbitration, then the parties are forced with having to refile a new action, and that's, you know, simply not a very convenient approach for the parties. And again, this is, you know, in line with what the First Circuit has done and the Third Circuit as well. So
I know that, but we are interpreting our rules, and while they are similar to the federal rules, and those rulings may be persuasive, isn't it basically when you file the motion to compel arbitration, you're basically telling the court, look, we have an agreement that this matter be arbitrated. Under the Federal Arbitration Act, the Supreme Court has basically says that the court has no discretion in effect but to abide by that. And normally, at least until recently, the court would dismiss the case once it goes to arbitration, rather than keep it on its docket, hoping that 10 years later, the parties may come back and say, we weren't able to resolve it, or we want to enforce the agreement, or the award. Recently, even in bankruptcy, when bankruptcy is filed, it stays the action. We have held that the court has the option to actually dismiss the case and allow the person to refile it after the bankruptcy is resolved, rather than keeping it on the docket forever while the bankruptcy drag on. So I'm just asking you why, since it is not listed as one of the items that the magistrate can address, and it is in fact the nature of a motion to dismiss or to terminate the court's jurisdiction, either by a dismissal or a staying while the arbitration takes place, why shouldn't that be something that the magistrate not be allowed to hear?
I'm
Your
sorry.
Honor,
Not, Attorney Alka, you'll get your time.
Sorry, I misunderstood. I thought you were directing it.
Right now, yeah, this is Attorney Kaczynski's argument.
Your Honor, it is not a dispositive motion, and that it really does not dispose of anything. With respect to the argument that it,
What are you asking the court to do with respect to its jurisdiction? When you file a motion to compel arbitration, what are you asking the court to do with the case that is before it and its jurisdiction with respect to that case?
you are asking the court to enforce the arbitration agreement between the parties and allow the parties to honor that agreement. And then afterwards,
to take it from the court and go to arbitration. Isn't that what you're asking?
no, Your Honor, you're at the initial stage of the motion to file to compel arbitration. You're merely asking the court to honor the agreement. And then afterwards, after the arbitration takes place, then a party would come back and move to and seek the court to enforce it. And with respect to the issue,
when the magistrate judge orders the arbitration, what is it doing with respect to the jurisdiction in the court?
it is, I mean, at the time, it is keeping its jurisdiction and allowing the parties to arbitrate. And an arbitration is a much faster venue than the normal civil process. And
I understand all that, you know, but I'm just wondering why not, if the magistrate is actually recommending, I assume, I don't know that it's a decision, he's reporting it to the magistrate would then recommend back to the judge what action to take, and rather than, and I believe that the motion to reconsider was properly back before the judge, but when Attorney Alcan, the plaintiff in this case, withdrew that motion, I guess that is where the confusion occurred. But I'm just raising the possibilities because I believe in Colombian, we discussed the fact that it could be dismissed or it could be stayed. And just wondering, isn't that a type of a dispositive motion when you file it? And does the magistrate really have the authority to rule on that particular type of motion? I know what you said, the Fourth Circuit and the Third Circuit has ruled with respect to the federal statute, but why should we follow that in this case?
Your Honor, there's a couple of things. One, superior courts in this jurisdiction have also, you know, essentially found that it is a non-dispositive motion. In Cornwall, the court did an extensive analysis about whether it should fall under is it equivalent to a Rule 56 motion or a Rule 12 motion, and the court essentially said, in that instance, it's neither because, you know, one, it doesn't have to be filed in lieu of an answer. It doesn't necessarily have to be an immediate issue. And then for that reason, the court doesn't have to put it into a box to say if it's dispositive or non-dispositive. It's enough that, you know, the court can simply address it based on the principles that it's already developed about enforceability of arbitration. And then it went on to address the issue about a stay versus dismissal. And it's apparent that a stay is the proper, you know, method because, and this was, I mentioned the First Circuit and the Third Circuit, but there's also a case involving other circuits and district courts where they said, you know, the court discussed the matter in detail, and because the parties basically, they have to be able to afterwards affirm, modify, vacate, or challenge the arbitration. The court essentially has to retain its jurisdiction in some manner to allow the parties to come back to it afterwards. And for that reason, you know, it's critical that it be stayed versus dismissed.
Well, attorney, I have a burning question. Do you have with you there section 4 BIC 123? Do you have that section there with you?
4 BIC 123? Yes.
Right, 123. That's the magistrate jurisdiction and authority that allows for the superior court to remand, to send things down to the magistrate for determination. If you can't find it, don't waste any time looking for it. It says here that the magistrate can hear and determine any pre-trial matter pending before the court, including matters before the family court, and then they have exceptions that the magistrate cannot hear. So would a motion to compel arbitration, would that not be a pre-trial motion pending before the court?
Yes, it absolutely would be, Your Honor.
Right. So then that would mean that it said hear and determine any pre-trial matter pending before the court, including matters before the family court, and then the exception, which means that there are certain things, certain pre-trial motions that the magistrate can't hear, but that is spelled out by the legislature, succinctly and artfully crafted as to those things that are excluded from the clutches of the magistrate. But where it says here, any pre-trial matter pending before the court is a motion to compel arbitration at a pre-trial matter that the magistrate would have jurisdiction over?
Absolutely, Your Honor. It's without question.
Particularly when, in fact, that all this thing the appellant talks about a waiver on the part of DVDV because of the protracted period of time before they finally get a ruling on the motion to arbitrate. But how could it not be a waiver after DVDV gave put up or offer the money to go to arbitration and the entire cost that and to participate in arbitration over a 2 to 3 day period with all these witnesses and whatnot. This would turn arbitration on its head if it's not a waiver. They agreed to go to arbitration both times, both with the agreement, and then when DVDV say, I'll pay the cost by participating in it. I don't see how it, I am hilarious. So how can we not find that the magistrate had authority? Because that would turn 123 on his head.
I agree, Your Honor, and I see my time is done.
Isn't one of the exceptions is an involuntary dismissal of the action?
That's what the statute says, Your Honor. But again,
so if
well, the matter is not being dismissed. The matter is being consistent with our idea of going to arbitration and to cut down on the cost. There's a whole body of law that says go to arbitration. It's an expeditious way to resolve your dispute. It cut down on the cost and everything. And it's not that the case is being dismissed. It's just that it's going to a forum agreed upon by the parties to arbitrate, which will make the determination. Binding arbitration, they call it, and it has its favorable aspects as to why people go to arbitration. We got to be very careful because
Attorney Attorney Alcon, you have 3 minutes.
Under the Magistrates Act, they accept from their authority to rule on summary judgment or failure to state a cause of action. This court has held that when they receive a motion to compel arbitration, we will treat it as either a motion to failure to state a cause of action or summary judgment, depending upon at what stage of the proceedings the motion is filed. Now, if in fact failure to state a cause of action under 12b-6 and a summary judgment under 56, Rule 56, is excluded from the magistrate's authority, we take the position that the Superior Court judge erred when he sent it down to them. If he had sent it to them to make findings of fact or recommendations, that's fine, but that's not what he did. He sent it down and told him to hear and determine. In my brief, hold that this is either a summary, we treat it as a summary judgment, or we treat it as failure to state a cause of action. And those are excluded from the magistrate's authority, and the Superior Court judge erred when he gave it to the judge magistrate to hear and determine. We never withdrew that objection. And indeed, you will note that the appellee we filed reminded the trial court that they still have, when I went back to them last year, they reminded the Superior Court judge, hey, you still have to rule on the motion to compel arbitration. That was never waived, Your Honor. The parties never agreed to it. Now, to tell me that I went to arbitration, I went there under the compulsion of the magistrate judge's order. And then I subsequently filed, when I realized that he didn't have the authority, I also said, he having no authority, there was no way I had to go to arbitration based upon an invalid order. And all I'm suggesting is, it's quite clear that.
But even if it was an invalid order, you did go to arbitration.
Well,
and the arbitrator ruled. So could you come back to the court after the fact and say, well, I made a mistake by going to arbitration, or I went through that knowing that it was a useless gesture?
No, I didn't make the mistake. They made a mistake when they gave it to the arbitrator. I cannot grant the arbitrator the authority to hear the case. Sir, he had no authority. He cannot rule on it. And to tell me that I didn't go to arbitration based upon the compulsion of the magistrate's order, I'm sorry, sir, it doesn't make any sense. All I complained about, once I knew I had to go to arbitration, I said the costs are too high. I withdrew that objection, but I never said that I agreed with the magistrate's order, and I couldn't.
Okay, thank you.
Thank you.
I have one last comment. Businesses better be very, very careful if to put in arbitration clauses in agreements if it's not going to be honored. It's very simple. Either it's an integral part of the contract, a material term of the contract, that our disputes will be resolved by arbitration, and then to later on said, that clause in what, a plot nickel or a shilling or a pence.
Okay, thank you all. The matter is submitted.